Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya, and in today's interesting episode of Polity Primer, we are going to answer a very important question, that how exactly in India the judges of the High Court and the Supreme Court are appointed. The title of our today's discussion is the Collegium System in India. In this discussion, we are firstly going to study about what is the Collegium System. Then we are also going to understand the constitutional provisions regarding appointment of judges. Then we are also going to analyze the evolution of the Collegium System. Then we are also going to understand the role of the central government in appointment of the judges. Then we are also going to analyze some of the criticisms of the Collegium System. We are also going to see a way forward in this regard. And lastly, we will analyze a practice question for your prelims examination and a practice question for your mains examination. So, if I talk about the background of our today's topic, recently a remark has been made, a statement has been made by our Minister for Law and Justice that Collegium System is opaque in nature and definitely it needs reconsideration. So, this brings us to the moot question of our today's discussion, that what is the Collegium System? How does it work and how does it is responsible for the appointment of judges to the High Courts and the Supreme Courts in India? So, if I talk about the Collegium System, it is not mentioned in the Constitution, not mentioned in Constitution, and neither it is a statutory body. What do we understand by a statutory body? A body that has been created through a law promulgated by the Parliament. So then you will ask me, ma'am, what exactly is the Collegium System? How did it evolve? So it evolved through judicial pronouncements. Judicial pronouncements. And that is why it is very unique in its characteristic. So, if I talk about the Supreme Court Collegium, so the Supreme Court Collegium is a 5-member body which is headed by the incumbent Chief Justice of India and comprises the 4 other senior most judges of the court at that point of time. So, same is the case with the High Court Collegium as well. It is also headed by the Chief Justice of that particular High Court along with his 4 senior most colleagues. So, by its very nature, the Collegium System is dependent on the seniority basis, and its member keep on changing because they occupy the position in the Collegium System only on the basis when they are senior. Okay, so when they are senior at the bench, and then only they can occupy their position in the Collegium System, and that is why by its very nature the composition of the Collegium System keeps changing. Moving forward to the constitutional provisions regarding the appointment of the judges. So, there are 2 very important constitutional provisions which talk about the appointment of judges. So, firstly is this Article 124 Clause 2, appointment of the judges of the Supreme Court. So, it gives the power in the hands of the President, power of the President to appoint the judges by his warrant and seal. Okay, so as per Article 124 Clause 2 of our Indian Constitution, the appointment of a Supreme Court judge is the prerogative of the President, is the power of the President, but President is required to consult such other judges of the Supreme Court as he may deem fit to be necessary. Okay, and this word consultation has often been in controversy, has often been the issue of various judicial pronouncements, which we will be discussing when we will be studying about the evolution of the Collegium System. So, he is required to consult such other judges of the Supreme Court which he may deem fit to be necessary. But the proviso to this article states that appointment of judges other than the CJI, other than the cannot happen without the consultation of the CGI. So it cuts some mandatory obligation on the President of India to consult the CGI when the other judges of the Supreme Court are appointed. Okay, same is the case with Article 217 also. It also mentions the power of the President to appoint the High Court judges. He has to consult the CGI of that High Court, the governor of the state. Okay, and while appointing the judges, again the power of the CGI becomes important. His opinion becomes important, and it is the president is bound to take his consultation. Okay, so the appointments are made by the president, as I have mentioned, who is required to hold consultations with such of the judges of the Supreme Court and of the High Courts as he may think is needed. So this is what I was explaining to you. Okay, but the Constitution does not lay down any process for making these appointments, and that is why Collegium is not mentioned in the Constitution. Neither does the Constitution lays down the exact procedure for appointment of judges. So this brings us to the another question of our discussion today, that how did the Collegium system evolve? So basically the evolution of the Collegium system happened through judicial pronouncements, as I have mentioned before also. So firstly, let us understand the appointment of the Chief Justice of India. So the Chief Justice of India is appointed by a convention, that yes, the senior most Supreme Court judge will be appointed as the Chief Justice of India. Okay, but this convention was broken 3 times in the history, and this is known as the supersession of judges. So we know that Justice A.N. Ray was appointed through superseding his seniors, okay, his colleagues who were senior at that point of time. Similar thing happened with Justice Beg as well. So these supersession of judges led to the breakage of this convention of appointing senior most judge of the Supreme Court as the CGI, and this again raised the questions about the appointment process of the judges. So the evolution of this collegium, as I have stated before, happened through judicial pronouncements, and the 3 judges case is responsible for the present evolution of the collegium system, the present existence of the collegium system. So the first judge's case, namely S.P. Gupta versus Union of India 1981. So in this case, by a majority judgment, the Supreme Court held that as per Constitution, the supremacy of the CGI is nowhere to be found. The Supreme Court said that yes, consulting the CGI is important, but consulting does not mean concurrence. What do I mean by this statement? That he has to be consulted, but it is not necessary that the president is bound by his opinion. So this was held in the first judge's case. That means the case gave the power to the executive, to appoint the judges. Okay, so this Supreme Court judgment shifted the power in the hands of the executive for the appointment of judges, and this prevailed for 12 years before this was challenged in the second judge's case. So let us move forward to the second judge's case, also known as SC Advocates on Record Association versus Union of India 1993. So in this case, the first judge's case was overruled by the Supreme Court. The Supreme Court said that no, consultation does not mean concurrence, is not a true position of law. In fact, consultation does mean that CGI has to be consulted mandatorily. Okay, so this led to the creation of the collegium system. So in this case, it was held that the president should consult the CGI plus 2 other judges of the Supreme Court. Okay, and consultation of the CGI was made mandatory, citing independence of judiciary as the basic feature of our constitution. The judgment in the second judge's case accorded primacy to the CGI in the appointment of judges, And it also held that consultation mean concurrence, which I have explained that yes, now the president was bound by the opinion of the Chief Justice of India. It now became mandatory for the president to consult the CJI before appointing judges. So basically it shifted the power of the appointment in the hands of the judiciary, again citing independence of judiciary as the basic feature of our constitution. Moving forward, then came the third judge's case. So basically after all of this mess, the president of India at that point of time asked the Supreme Court in its advisory jurisdiction under Article 143 to interpret this word consultation, to lay down guidelines regarding the appointment of judges. And it was also asked that whether this consultation included the sole opinion of the Chief Justice of India. So, consequent upon doubts having arisen with the Union of India about the interpretation of the second judge's case, the President of India in exercise of his powers under Article 143 referred 9 questions to the Supreme Court of for its opinion. So, this was a precedential reference to the Supreme Court under Article 143 of our Indian Constitution. Moving forward, the Collegium of Judges headed by the Chief Justice of India has been vested with the final determinative authority for making appointments to the higher judiciary, and the President is liable to concur with the recommendations made. The Supreme Court bench in this case noted that the expression consultation with the Chief Justice of India in Article 217 clause 1 of the Constitution of India requires consultation with a plurality of judges in the formation of the opinion of the Chief Justice of India. So the Supreme Court said that no, only the sole opinion of the Chief Justice of India is not important. You have to consider plurality of judges. And the Supreme Court in this case said that not only the CJI plus 4 other judges should be consulted, 4 other senior judges. So in the second judge case, the Supreme Court said that CJI plus 2 other senior judges, but in this case, the Supreme Court said that CJI plus 4 other judges, 4 other senior judges, CJI plus 4 other senior judges. Okay, and this case laid down the present collegium system, as I have explained that the Supreme Court collegium as well as the High Court collegium consists of the CJI plus 4 other senior judges of that court. Moving forward, the Chief Justice of India is not entitled to act solely in his individual capacity without consultation with the other judges of the Supreme Court in respect of materials and information conveyed by the Government of India for non-appointment of a judge recommended for appointment. And this led to the expansion of the collegium system, that yes, CJI should consider other judges of the Supreme Court, and that led to the formation of the present collegium system with CJI as its head plus 4 other senior judges of the Supreme Court, and they sat together to appoint the judges of the Supreme Court as well as in the various high courts in India. Moving forward, what is the role of the central government in the appointment of judges? So, the central government plays a very limited role in the appointment of judges as of now. The government's role is limited. It can only get an inquiry conducted by the Home Ministry if a lawyer is to be elevated as a judge in the High Court or the Supreme Court. It can also raise objections and seek clarifications regarding the collegium choices, but if the names are again reiterated by the Supreme Court collegium, then the government is bound to appoint those persons as judges. So the government plays a very limited role, because this was established through the judicial pronouncements that yes, the executive cannot have a say in the appointment of judges because of the independence of judiciary is a basic feature of our constitution. Okay, and that is why the power of the executive in appointment of judges is very restrictive in nature. Moving forward, what is the criticism of the collegium system? See, collegium system often remains in the debate also, and the present statement by our law and justice minister also triggers the same question that yes, collegium system has been criticized on various grounds. So the first ground of criticism of the collegium system is the lack of accountability and transparency. See, collegium meetings happen in a very closed door. They happen apart from the eyes of the public. The public has absolutely no knowledge about the eligibility, the manner in which the collegium considers the appointment of judges to the superior courts of our country. Okay, there is no public knowledge of how and when a collegium meets and how it takes its decisions, and this is the focal point of uh, criticism, and that is why our law minister also said that yes, the collegium system is very opaque in nature. It is not at all open to the public, neither does the public know that how are the judges of the Supreme Court and the High Courts in India are selected. There are no official minutes of the collegium proceedings, and this also forms another major criticism of the collegium system, that yes, it happens behind closed doors. No one knows when they meet, how they meet, and there are no official minutes of the meetings. Then the judiciary has a lengthy history of nepotism as well, which has been noted time and again by the central government as well as various lawyers as well. I'm not saying so, but yes, it happens that if someone from your family is already on a very high position, supposedly he is a high court judge or a district court judge, then your chances of becoming a judge becomes higher due to the prevalent nepotism in the collegium system, and that is very noticeable as well. The newspapers also point out this apart from the government. So these were some of the points of criticism of the collegium system. Now let us understand what can be the way forward. How can we improve the collegium system? So if you'll ask me, ma'am, what can be the way forward? So firstly, make the collegium system accountable. Make the collegium meetings happen in a structured way. We should also know, right, that how are the judges of the superior courts are appointed by the collegium. So they should have the formal meetings instead of closed door meetings, and they should tell the exact eligibility criteria that on which they are judging the merits of a particular person who is being nominated. Then the collegium should also understand the point of the central government as well. If the central government is asking the collegium to reconsider the decision, definitely they should pay heed to the opinion of the central government as well, and they should not promote nepotism in the legal field, which is frequently happening. So the person should be considered on merits rather than being considered on his or her rather than being considered on his or her family background. So the collegium system must be accountable and transparent, and definitely they should publish a meeting minutes of their meeting, and they should be very transparent about when are they meeting and what is the eligibility criteria, what is the merit standard on which they are considering a particular candidate. So these can be some of the reforms that can be made in the collegium system. So there was this NJAC as well, or the National Judicial Appointment Commission, which was passed in the year 2015, but this was struck by the Supreme Court as being violative of the independence of judiciary. So time and again it has been said that NJAC should be reconsidered, and reforms should be made in the NJAC, and then collectively the executive and the Supreme Court can work together to appoint the judges of the superior courts in our country. So with this, we come to a conclusion of our today's discussion. We have seen that the collegium system is responsible for appointing the judges of the superior courts in India. We have also seen its evolution. We have also discussed that why the collegium system is being criticized, what is the role of central government, and we have also seen the way forward in reforming the collegium system. Now let us analyze a practice question for your prelims examination. So the question is, which of these statements are not true with respect to appointment of judges? Your statement number 1 is second judge's case revolved around the term consultation in the appointment of judges. Your statement number B is Justice M.N. Venkat Chilaya Commission was appointed to examine whether there was a need to change the Collegium system. Your statement number C is the judgment in the first judge's case title till your statement number C is the judgment in the first judge's case tilted the balance of power in appointments of judges of the high courts in favor of the executive. Your statement number D is the Collegium system is not rooted in the constitution or a specific law promulgated by the parliament. So, which of the following statements are correct? Kindly mention in your comment box below. Let us analyze a practice question for your mains examination. So, the question is examine the opportunities and challenges related to the Collegium system of appointing judges. So, firstly, you will mention about the Collegium system as I have mentioned in my discussion today. You will write that yes, it is not a constitutional body, neither a statutory body, but a very unique body that has been evolved through judicial pronouncement. You will write the Supreme Court Collegium, High Court Collegium, the constitutional provisions. For example, Article 124 Clause 2 and Article 217. Then you will discuss the evolution in brief, the first judge's case, the majority opinion in that case, the second judge's case and the third judge's case. And then you will write the criticism of the Collegium system, and then you can suggest some of the way forward that yes, NJSE could be reconsidered as has been opined time and again by the various experts and the central government, and definitely the executive and the Supreme Court can come together to appoint the judges in the superior courts of our country. So, basically it can be a joint exercise between the executive and the judiciary, which will also not hamper the basic structure of our constitution. Okay. So, you can conclude holistically that yes, independence of judiciary is important, but there can be a midway also that can be evolved through the joint functioning or joint cooperation between the executive and the judiciary. You can conclude very holistically. So, I hope this session was insightful for you. If you found today's discussion to be helpful, kindly like the video and subscribe to our channel for more such updates. If you have any feedback regarding this session, kindly drop it in the comment box below. Thank you.